Greetings. The purpose of today's presentation is to take a closer look at some of the claims made by MTF and to analyze them and to ascertain their validity. Now, the first claim is related to an obligation set out under Article 35, Paragraph 1, which talks about the fact that the goods delivered by the seller must be in conformity to the contractual agreement. Now, of course, even such obligations have constraints to them, and such constraints are set in Article 38, Paragraph 1 and Article 39, Paragraph 1. Now, 38 sets out the obligation to examine the goods within a short period of time, and Article 39, Paragraph 1 also sets out the exception by saying that the buyer loses the right to rely on the claim for lack of conformity of goods if he or she does not examine the good within a reasonable period of time. Now, in order to determine what is exactly the reasonable period of time, we're going to have to take a look at some of the case law related to these particular circumstances, and moreover relate that case law to our particular situation. Now, the case that we're going to take a look at today is the plastic granular case, or otherwise known as Case 167, in order to ascertain what is the definition of reasonable time under Article 39, Paragraph 1. Now, we're taking on this case because it's quite a similar case to ours, since it deals in the chemical field and it also deals with issues of nonconformity of goods and a late inspection. Now, in this particular case, the court sets out 8 days for inspection. So from the time of delivery, there's an 8-day period which is appropriate in order to inspect the good and send a notice of nonconformity. Now, if we apply this to our situation, the delivery was made on the 1st of February and the inspection was made on the 7th of February, which is well within the 8 days set out in the criterion of the plastic granular case. However, the same case outlines that if the payment occurs after the delivery, the inspection must be finished before the payment. In our particular case, the payment was made on the 4th of February and the inspection on the 7th. Therefore, the inspection was performed after the payment, falling outside the criterion set in the plastic granular case, which means that MTF loses their ability to claim for nonconformity under Article 39, Paragraph 1, since they did not provide a notice within the reasonable time in the eye of the court according to case law and the interpretation of Article 39, Paragraph 1 by the German and Austrian courts. Now, the second claim that is related to the nonconformity is the impediments to examination. Now, this claim could be raised as a cop-out or a way to avoid liability for the lateness of the inspection. This right is set out under Article 79, Paragraph 1, and states that the inspection of the product could have been delayed, and the burden for such delay can, of course, relinquish any responsibility for MTF, and if, of course, the impediment causing it is outside of the control of MTF. However, after some investigation, we have found out that there has been no such impediment which might have caused delay that has been outside of control of MTF. Now, another claim that could be potentially brought up by MTF is the claim that the contract amendments must have been done in writing. And of course, the contract does indeed specify that any amendments done to the contractual agreement must be done in writing. And moreover, Article 29, Paragraph 1 of CISG further supplements that by saying that if there is indeed such a clause in regards to amendments being done in writing, such clause will prevail. However, even such article has an exception. This exception is set out in Article 29, Paragraph 2 of the CISG, which states that the conduct must also be taken into consideration, and that it is very vital. And it takes on the consideration that the conduct of the party must not contradict itself. Now, if we look at, and of course this particular stance was also supplemented in the case 94 or the VN case. Now, if we look at our particular case, it could be interpreted that MTF's conduct conveyed that they accepted the oral amendments to the contract by not only not responding to the non-delivery notices, but also by accepting the goods on the 1st of February. Such action of accepting the oral amendments would contradict their further action by relying upon the no oral clause within the contract. Now, what does this exactly mean? This means that any reliance on claims that the amendments must have been done in writing could be perceived as abuse of no oral modification clause, and of course prohibited under Article 29, paragraph 2. In fact, the same article takes it upon itself to prevent such abuses of the no oral modification clauses. Now, the next claim made by MTF was the fact that they mitigated losses. Now, this claim would be much harder to dismiss since it does have merit. MTF did indeed mitigate its potential losses under Article 77 and has done so in a reasonable way. Now, they have mitigated their losses by finding an alternative supplier in Belgium, and the price paid for the alternative supplier was very, very much similar to the price of the original contract with us, and therefore could be regarded as reasonable since the prices are comparable. Moreover, it is indeed a mitigation of loss, since if such action would not have been done, there would have been potential profit losses and even a reputational damage. Therefore, by getting an alternative supplier in Belgium, MTF did indeed mitigate the losses. This means that this particular claim could indeed be perceived as valid and would find much harder time to be dismissed in court. Now, the relief sought by SPR is to dismiss any claim in regard to the goods delivered being in nonconformity to the contract, and this dismissal is very much hinged upon the fact that the notice for the nonconformity of goods was issued by MTF not within a reasonable period of time under Article 39, paragraph 1, and under the same article, such right for claiming nonconformity of goods is relinquished if the notice is not given within a reasonable period of time. Furthermore, SPR seeks to establish that any amendments made orally to the contract should be perceived as the same ones as done in writing, and the reason for that is very much set under Article 29, paragraph 2. So these are some of the relief sought by SPR in regards to the claims made by MTF. Thank you so much for your time and for your attention, and I hope I have informed you sufficiently. If you happen to have any further questions, please don't hesitate to contact me and let me know. Thank you very much. Have a great day.